It's Rebecca Masterson. I am Chief Counsel of Gen Justice, and I am first and foremost so excited that we had such a tremendous response to this presentation. Every time we host a presentation, I am inspired by the amount of people that want to learn more about the foster system and advocate for the kids in foster care. So thank you. For those of you, and I know there's quite a few of you, that have attended one of our educational presentations before, this is a little different. We're trying a new series, and it's a lunch and learn. And we are going to pack in as much information as I can in the lunch hour. So what we're going to do this time is I'm going to go from beginning to end, and I'm going to do the entire presentation, and we will do questions at the end. So feel free, you all have a Q&A chat box. Feel free to put all your questions as you go along or write them down and save them for later, and I promise we will get to them. And we have one of our lawyers, Brittany, is monitoring and sorting the questions, so I promise you we will get them. So without further delay, let's get started because I know we're on a time frame here. We're here to talk about a new law, SB 1391, and we're going to understand Arizona's new law that gives an attorney to every single foster child. If you can tell by my smile, I am ridiculously excited about this. Before we start, for those of you who don't know, let me tell you a little bit about Gen Justice. Gen Justice is a Phoenix-based nonprofit, and quite simply, we work to mend the child protective system. We are working to mend the foster care system. We do this in many ways. One of the ways we do it, and the way that I'm most familiar with, it's my job here, is we develop laws that put the child front and center of their court case. So we've passed about a dozen laws at this point, over a dozen actually. Most have been in Arizona, but as I sit here right now, we are helping pass legislation in 5 states. So we are now having a nationwide reach. And every single one of the laws that we pass at Gen Justice, that we help pass, focuses on what's best for the children that are in the foster care system. SB 1391 is based on the simple premise that children deserve the same rights as everybody else in their court case. Quite simply, SB 1391 gives Arizona's children the right to attorney representation. Before I get into the nitty-gritty of the bill, let me tell you that it passed unanimously. And I say that because it makes me really, really proud of Arizona and our state. There was not a single dissenting vote throughout the entire process. Arizona lawmakers were nonpartisan when it came to a crucial legal right for children. It was signed into law on April 4th, so just a little bit ago, by Governor Ducey. And when it takes effect, I can't give you an exact date, but this is a question I've gotten quite frequently. It takes effect 90 days sine die. And yes, I had to write down the pronunciation for myself and highlight it over here. You didn't know you'd learn a little Latin in this presentation, but there you go. What sine die means is when the legislature adjourns. Let's see, about 2 years ago, not last year because of COVID, about 2 years ago, the legislature adjourned at the end of May, which would mean that this law would take effect at the end of August. So that's something that you can check the websites for of when the legislature adjourns. We've got 90 days to prepare, and then SB 1391 and all of the laws that have been enacted in Arizona this session will take effect. As I think just about all of you know, when a child enters foster care, a court case is started. So prior to this law, in that court case, parents were guaranteed an attorney. The department, DCS, was guaranteed an attorney. The children were not guaranteed an attorney. So I know a lot of you are thinking right now, like, wait a minute, Becca, I'm pretty sure that my foster child had or has an attorney. Can you tell me what the difference is and why this law is so important? And I would absolutely love to. First of all, if any of you are from Pima County, you're absolutely right. The child in foster care that you were taking care of had a child lawyer. For those of you who are dialing in from Maricopa County, in the Phoenix area, your foster child had a guardian ad litem, or what's called a GAL. Now in Maricopa County, the GAL had a law degree. So the GAL was actually a lawyer. Now that was practice, that was not law, and that could have changed at any time. But the practice was that Arizona GALs had law degrees and were lawyers. But this is the crucial difference. GALs did not represent the child. Okay? GALs did not have an attorney-client relationship with the child. This law changes that. Let's talk a little more about that. The biggest question, in addition to the wonderful messages of congratulations for all Arizona's foster children, the biggest question we get is, what is the difference between a child lawyer and a GAL? And that is an exceptional question. And we spent a lot of time with lawmakers on this exact point. A child lawyer represents the child. Think about it in the most traditional context. As an adult, you've got a legal issue, you go out, you hire a lawyer, that person is your lawyer. There is an attorney-client relationship there. That's what a child lawyer in this new law provides to Arizona's foster children. Conversely, a guardian ad litem does not represent the child. Okay, there is not an attorney-client relationship there. The GAL's duty is to the court. A GAL is actually a court advisor. So they advise the court about what they think is best for the child, but they don't represent the child. This is a really big point. Attorneys in Arizona, and in every state actually, are bound by what's called rules of professional responsibility. Sometimes the shorthand is called ethical rules or lawyer rules. These ethical rules are binding on lawyers. We have to comply with them, or we are subject to discipline by the state bar. All lawyers, all child lawyers who now have a client and represent a client will be bound by these ethical rules, these rules of professional responsibility. And this is a really big deal because there's quite a few rules. A big one is that you have to advocate for your client. You have to, or you're subject to state bar discipline. Okay, this is the child lawyer side. A guardian ad litem has actually no obligation to advocate for the child's legal rights. Okay, and it makes sense because they're actually there for the court. They're there as a court advisor. They don't represent the child. So they're not bound by these ethical rules like every lawyer who has a client is. So what that means is that a child lawyer will have to advocate for the child's position. So that means that for foster children in Arizona, a child lawyer will file motions and pleadings and oral arguments, and they will have to advocate for a legal position that serves their client. The GAL did not have that obligation. Now I know some of you are like, I had an amazing GAL, and some of you are like, I had an average GAL. This makes all the rules the same. You don't have to be exceptional to comply. You now have to comply because you have an attorney-client relationship and you have a client that you're representing. Another really, really, really important distinction between a child lawyer and a GAL is the State Bar of Arizona. So lawyers who practice in Arizona are subject to independent oversight by the State Bar. So these ethical rules that I'm talking about, these rules of professional responsibility, if a violation of one of these rules is reported to the State Bar investigates and, if warranted, disciplines that lawyer. So I'm sure a lot of you have heard the phrase disbarred or lawyer sanctioned or censured. This is that process. There is an independent investigatory process that makes sure that lawyers are complying with their ethical rules. Because the GAL isn't obligated to necessarily comply with those rules, the State Bar oversight isn't triggered. And so this is also a huge and critical protection for kids in foster care. If you guys are saying like, wow, these rules sound like a really big deal, they are. Trust me, they are. It's something you discuss in law school. It's something you do in practice. Lawyers, like foster parents, have to do a certain amount of continuing education every single year. And a portion of that education has to be on these ethical rules. So it is something that is ingrained in the practice of law and something that lawyers are very, very serious about. And if you're not serious about it and you don't comply, you can get disciplined by the state bar. So they really are a tremendous deal. And now we're bringing all of the protections of those rules and applying them to kids in foster care. So some more about these rules. Now that these kiddos are the client and the attorney represents the child, what is the change? What must a lawyer do? And I'm stealing these are quotes. So a lawyer must act with commitment and dedication to the interests of the client. So they have to work. They have to advocate for the legal rights of their client. They have to act with diligence and promptness. And I know a lot of you are hopefully cheering like I am when you hear the word prompt and diligent. A lawyer representing a client has to take whatever lawful and ethical measures are required to vindicate a client's cause. Now let's pause on that one, because in foster care, what is the child's cause? Well, the child's cause can be many, many, many things. The child's cause can be not delaying a court case. A child's cause can be permanency. A child's cause can be seeing siblings. A child's cause can be any number of things that's in the best interest of the child. And these ethical rules say that the child lawyer will take whatever lawful and ethical measures are required to vindicate a client's cause. And then finally, in an attorney-client relationship, a lawyer must make efforts to expedite the court case. That means no undue delays. That means no unnecessary continuances. If it's not in the client's best interest, if it's not helping that child, a lawyer has a legal and ethical obligation to say, this isn't in my client's best interest, and I'm going to oppose it in court. So this slide right here, every single one of these quotes comes from those ethical rules I told you about. These are the rules of professional responsibility. They're not super exciting, but feel free to Google them. Rules of professional responsibility of Arizona. You will see all of these rules, and these are just 4 of the many, many rules that a child lawyer will now be bound by when accepting a case that represents a client. Let's get really specific. What will this mean for kids in your care? What I expect it to mean, what I certainly hope to see, and what I know the Office of the Child Lawyers is intending to provide for these children with attorney advocacy are less court delays and unnecessary continuances. And that comes up a lot. And I see it and you see it. And somebody in the case has what we consider sort of a weak excuse to not be able to attend a hearing, and that bumps the hearing for the child off several months. Now the child's lawyer has the right and the duty and the obligation to say, let's get a quicker date, or let's not move it at all. I think this will also mean more motions filed on behalf of children. Motions are pleadings, are written documents that are filed to the court. The court reads them. They contain legal arguments for the different positions. So these are things that DCS files on their behalf through their attorney, and the parents have filed through their attorney, and the child didn't necessarily have anyone filing motions before the court for the court to consider on behalf. There should be, in general, more advocacy on behalf of children. Okay, there should be more arguments, there should be more pleadings, there should be, to state it simply, more lawyering on behalf of children and what they need to get in and out of the system safely and be better protected. I hope that this will mean less time in the system. And there is research out there, and I'm not going to bore you with a bunch of statistics, I promise, but there is research out there that says child lawyers result in much less time in the system. Children who cannot safely go home can be adopted up to 3.5 times quicker. And I think if you consider that there will be less court delays and continuances, you can see how this might speed up the system. We are not, and by we I mean Arizona. Arizona is not the first state to appoint lawyers for foster children. But I will tell you, and I'm really proud of the way we did it. We did it well. We did it thoughtfully, and we spent a lot of time on it. And I would say we are, once this is enacted, going to be one of the best states in the country on this issue. And here is the reason why. Other states that provide their kiddos in foster care attorneys put in a lot of caveats. They will say, for example, a child in foster care will have their own attorney at the age of 10 and up. Or a child in foster care will be appointed an attorney if the case is going to severance. Our law doesn't have any of those caveats. Arizona says a child in foster care will be assigned before the first hearing. Okay, so as we already talked about, when a child enters foster care, there's a court case. At that hearing, the court will appoint a lawyer. There will be no delay and there will be no waiting from the get-go. The Arizona law says that a child will have representation at all stages of the case, not at TPR, not at dependency, not at any of these stages, the entire case, and this is important, until permanency. So this means that some of the kids who are severed from their parents, but they haven't had an adoptive family or a guardianship come through for them, they will still have an attorney there to fight for their rights, to fight for their best interests, and to make sure, let's say they have an issue about a placement, or they don't feel safe, or they have a school issue, they will still be represented. Arizona's law does not start or end until, it does not end at a certain time. It ends at permanency when the court case is closed. We intentionally and specifically did not put any age limits in our law. It's going to look different for infants, of course, and very young children, and we will talk about that in a little bit. But infants deserve the same level of advocacy and the same level of protection as a child who's 10 and up. You know, for example, in those other states. The Arizona law, once a court case is filed and a child enters foster care, no matter the age, that child will have a lawyer. Can GALs still be appointed? Absolutely. Because guardians ad litem are court advisors, okay? A court at any point can say, this case is very complicated, or this case is very unique, and I would like a guardian ad litem. And the court can assign the guardian ad litem, who will be a separate person at the table, in addition to the child lawyer. The child lawyer is now guaranteed. The court can also, under its own discretion, appoint a GAL. And that, just by the way, is the same as it works for the parents in these court cases. The parents are automatically assigned with the same parameters a parent's lawyer. A court can always say, this is tricky. I think I need a GAL to advise me on the bench, and that's perfectly acceptable, and this law does not change that. CASAs. CASAs have not changed in this law. CASAs may absolutely still be assigned. There is nothing in this law that's going to change the important role of CASAs in Arizona. Okay, I see your questions coming in. Don't worry, Brittany's got them. But I do have a couple frequently asked questions. And I know I'm a quick talker, but I know there's going to be questions. And I wanted to do my best to finish up in 45. So I've got about 10 more minutes of the frequently asked questions, maybe a little less, and then we're going to go to your questions. So I know the biggest question is, what are you going to do? How is a child, an infant, going to tell their lawyer what they would like to do in the case? They won't. They're an infant. There is a doctrine in the law called substituted judgment. And I'm not going to bore you with the details, but just know that it's governed by those rules I told you about of professional responsibility. It's a very common practice in the law. And what it's going to look like is that for young children and for infants, the child lawyer will look a lot like the GALs, okay? With the difference of they have a duty to advocate. They have a duty to be a lawyer. But they can look at the situation, they can interview, they can talk to foster parents, they can get all the information and make a judgment about what's in that child's best interests and then advocate that position to the court. So that's how it's going to work for infants and young children. And there are some states that don't provide infants lawyers. Personally, I find that to be a tremendous legal injustice, because just because they can't speak to the court or stand up on their own 2 feet doesn't mean that the advocacy should fall short. And so in Arizona, it will not. Number 2 is, can siblings be represented by the same lawyer? And I'm going to give you a really solid answer of probably. Okay, probably. Siblings can be represented by the same lawyer unless there's a legal conflict. I'm not going to go into what a legal conflict will be, but it's pretty rare for siblings. This will be addressed and handled in the court rules, which I'll talk about in just a little bit. But for the most part, I know some of you amazing people out there foster more a sibling group. And it might be easier for the attorney to represent all the siblings at once. And unless there's a good reason not to do so, yes, that's going to be able to happen. Number 3 is, can a child lawyer talk to foster parents and relative caregivers or kinship providers? Absolutely, yes. Now, the law doesn't say they have to, but the court rules will, okay? A lawyer has an obligation to investigate the case. They have an obligation of due diligence. They have an obligation to do what's best for their client. And so if that lawyer thinks that talking to the foster parents or kinship providers is helpful, that lawyer will do it. It's going to look a lot like a GAL. Like sometimes it's helpful and necessary, and sometimes it isn't. And we will get more clarification about that in the court rule. Number 4, I'm going to touch on very, very briefly. It's the attorney-client privilege. The attorney-client privilege, for those of you that don't know, is really a zone of privacy. A client can tell their attorney something and expect and is entitled to privacy. Okay, that means the attorney cannot tell anybody else. Okay, now more often than not, when a client tells their attorney something, the attorney asks them if they can alert the court, or can I use this in a motion? Of course, that's just the practice of law. But what I have found is that it's really very helpful to children. It protects them. Oftentimes, the attorney-client privilege protects children from a disclosure that would put them in harm's way, okay? Because this privilege did not exist before this law. So if a child told a guardian ad litem something that might put them in harm's way, the GAL had no choice but to inform the court in open court sometimes. This will not happen anymore. But for those of you that are worried that the attorney-client privilege, if a crime is about to be taken, please do not worry. There are also exceptions to this rule. Finally, what are court rules? Because child lawyers are appointed by the court, it's a court function. Okay, so the procedures and the details and the nitty-gritty of how this is going to happen are all going to be encompassed in court rules. So when a law changes that affects what the court is used to doing, the next step is to develop and change the rules that support it. So that's where we are in the process now. There is a committee of people, and we have certainly lent our voice to this committee and are actively lending our voice to this committee of what the court rules need to do to supplement the law and make it work as absolutely solidly as possible for Arizona's foster children. Court rules will have some really boring things in there, like, you know, time frame of motions, but it will also have some things in there like, does the attorney have to investigate and talk to the foster parents? It'll have some really good information in there, and they are always published once they are drafted. Okay, guys, that was a quick and, you know, down and dirty presentation about this new law, SB 1391. So I keep using the bill name. It's Senate Bill 1391. When it's enacted, 90 days sine die, it will be in a statute. It will be in an Arizona state law. Really quick, before we go on to questions, and I see many here, I need to plug the organization that I work for, Gen Justice. We get so many wonderful messages. We have been just flooded with messages about this law. And yeah, I'm not gonna lie, we're pretty excited about it too. This really is a game changer for Arizona's foster children. And we are the only organization in the country doing what we do. And to state the obvious, I need to tell you that it isn't free. So after this presentation is over, if you hang tight, it will direct you directly to our website, where you will find that we are a qualified foster care organization, and we definitely qualify for that tax credit, and any donations that you would like to offer would be phenomenal. genjustice.org, or again, stay on the presentation and it will take you directly to our website. Okay, we are going to head to questions now, and we have about 15-ish, 20 minutes for the questions. So I've got Brittany here, and she is the lead attorney for our Children's Law Clinic, and she has been monitoring because I know we have a lot of duplicative questions, and she's going to read them, and we're going to do our best to answer everything.
Hi, everyone. This is Brittany. Lots of great questions have come in, and I'm just going to go through them. So I'll start with this one. Rebecca, how will ICWA interact with the appointment of a child's representation?
That is a phenomenal question. ICWA children are in the state court system like any non-ICWA child until they aren't, for lack of a better word, until and unless a tribe comes in and removes the case because the tribe has jurisdiction. So the quick answer is, as long as that child is in a Arizona Superior Court, that child will have a lawyer. Okay, so once that court case is filed for a child that is ICWA qualified, that child will have a lawyer. Now, if the tribe removes the case, then our state law does not apply, and that's a completely different system.
Great question, and I will be filling out answers to these just for everyone listening as well, and we'll publish them just to avoid the duplicativeness. So hang tight for that. A similar ICWA question, Rebecca, is, are there any restrictions if it's an ICWA case? And so you kind of answered that, but it's a little different than the one that we just had.
I mean, I will say that ICWA is very different, as those of you ICWA certified know. And so all I'm really able to talk about right now to keep this presentation short and sweet and a lunch and learn is the effect of this bill on a child that is ICWA qualified. So again, if that child is in Maricopa County Superior Court, for example, that child will have a lawyer with the same protections that we just discussed. If that case is removed, it would be up to the tribe.
Great. Some people are asking, will they get a copy of this PowerPoint?
Sure. Sure, we can make that happen. How about this? How about I say yes, absolutely, if you want it. How about I will send it to everybody who registered and attended the list. And if I miss you, or if Brittany misses you, the email that you can follow up with is hello@genjustice.org. hello@genjustice.org. But yes, we will send it out after the presentation.
When this goes into effect, what kind of training about the foster care system and processes will child lawyers be required to have?
Phenomenal.
I'm sure there. Oh, sorry. There's. Go ahead and answer that. There was a little more, but it wasn't a question part.
That's a great question, and let me just tell you that the head of the Maricopa County Department of the GALs was on board with this bill. He's excited about this bill, and he will also be in charge of the training. And he has asked for our input on that, and that will be something that will be encompassed in the court rules. So that's something that we passed this law. Again, we kind of have to wait for these rules to come into play. but there will be a training component absolutely to this because it is a different role.
Okay. And similarly, there were some questions on, sorry, I scrolled to the wrong part. What the expectations of these attorneys will be in terms of training in things like trauma, as well as the overall foster care system and specifically juvenile court. So you already answered that with those.
Keep your eye on the court rules. Let me just tell you that we are extremely cognizant of the fact that passing this law is a first and amazing step. The second part of this is making sure that we can change the culture, that the child lawyers really should be the best they absolutely possibly can be. And so we are working very hard to make sure that they get the training that they need to work as hard as they possibly can for these children and advocate for their legal rights.
Does the GAL now become the child's attorney, or is a separate lawyer appointed?
So part of that is going to, again, come from court rules. The court rules really do define, like the law is the big umbrella. The law says every single child in foster care gets a lawyer. The court rules are really going to provide some of these details. But because Maricopa County's GALs all happen to be attorneys, yes, these GALs will now take off the GAL hat and put on the child lawyer hat. Now, what's going to happen between that hat change is training, okay? The court rules are going to be implemented. There is going to be training. There are going to be seminars with the judiciary and the bench. And we are thrilled to be a part of that and to advocate on behalf of the children. I don't have an answer as to if a child has a lawyer and needs a GAL, where the GAL will come from. I don't have an answer as to how they're going to divvy up the department that way. I can just assure you that if a child needs both, the child will have both. It's a really good question, guys.
Mm-hmm. There's been several people asking what will happen to the current GAL on a case for counties like Maricopa where there's not already a lawyer. Does that person change and take on the role of a lawyer, or will it be a whole new person if we know?
So that brings up a really interesting question of what happens to children who are already in the system and have a GAL. And that is it's a complicated legal question that we are researching and weighing in on. There's no question that every child that comes into care, once the bill is enacted, seeing a DA, they will have a child lawyer. The children currently in care, if that transition is made from GAL to child lawyer, I think it could be the same person. They may decide to appoint a new lawyer, but for consistency's sake, it would probably be the same person. But again, I'm speaking about something that may be addressed later. So there's a little bit more information that we need to do now that this has been signed to get that answer to you.
What is the obligation for a lawyer if a child wants something that is not, quote, in the child's best interest? Example, a child only wants to go home and not other permanency, but the department is moving toward a severance.
The department is moving toward what?
Toward a severance.
So this is what's called client-directed lawyering, and it's a fundamental principle in our legal system. That could happen. You could have a 16-year-old child who is going to direct his or her lawyer to argue for something that somebody else may not feel is in his or her best interests. Okay, and a couple things can happen here. First, I want to say that I think it's very important that we listen to the voices of the children in care. Okay, I think it's important that they have the same legal rights provided to everybody else in that courtroom. Second, if the child is promoting his or her own argument that's not in their best interests, like this example said, DCS usually has that covered through their attorney. Okay, so if you've got a kiddo that's saying I'm forcing my child or I'm forcing my lawyer to argue that my permanent case plan should be a vacation to Costa Rica, I mean, that's great. But the other lawyers in the case are probably going to put forth some more solid arguments before the court. The third thing that will happen is don't forget that a court can appoint a GAL. So if you have a very tricky situation where a child's lawyer is making an exceptional argument for something that the court just isn't sure is in that child's best interests, the court can apply a GAL, that guardian ad litem, to do a separate investigation and advise the court. So there are ample protections for this situation. Just to follow up on that, one question we've gotten a lot is, now that these kids are represented by attorneys, can they waive their representation? And the answer, like most everything else, is it's going to be up to the court, and it's never happened. It's never happened in Pima County, where they've had child lawyers for years. I've never seen a successful case, and I have asked around, that there has never been a case where a child was able to convince a judge to not give them some sort of protection through a GAL or a child lawyer. So you need to remember that all of this lawyering is arguments that go before a court, and the court is the one that makes the ultimate decision. And if they don't feel that they can make the decision without additional help, they'll get the additional help. Anything else, Brittany?
Yes. Sorry, I was clicking back to that. Will the child keep the same lawyer throughout the case?
I can't answer that. I mean, in an ideal world, of course, but there's turnover and kids move. And I mean, I'm sure that the goal will be to keep it as solid, as stable as possible, but some of that is just out of the control of the law.
Does this law change the timeline when a foster placement becomes a kinship relationship?
No, that's a completely separate law. And I think you're referring to, that was our law also. So I can speak on that pretty solidly. You're talking about a licensed foster placement who has had a young child for 9 months or more becomes what's considered a kinship or fictive kin placement. This law has nothing to do with that. This law actually, in my opinion, would bolster that law, because if it's in the best interest of that child now has a lawyer to advocate for that law. They have the oversight to make sure that the law is being followed. Good question.
Will the attorneys be able to continue to use a social worker to see the children on their cases, or will they have to see them themselves more frequently?
I hate to keep saying this because I would love to know the answer to that myself, but that's going to be court rules. That'll be discussed in court rules. I don't know the answer. We will know the answer, but I don't know that today.
I think you answered one similar to this, but just to reiterate, because it is a very common question, is it true that the lawyer advocates for the children's wishes and not particularly for their best interests, whereas a GAL advocates for the children's best interest and not for their wishes?
So there's a lot to that question. First of all, the GAL has no duty to advocate at all. So if you have a GAL who's been advocating, fantastic. But that's not what the law doesn't require that. The law will now require an attorney to advocate. And the answer is yes, sort of. I mean, it is different because we're talking about children. But for young children, no. For young children, the lawyer will advocate a best interest assessment usually. For older children, the attorney will likely argue exactly what that child wants. Now, that doesn't mean that there's not legal counseling and legal recommendations and meetings with their client on the side. I mean, that's what we do as lawyers. And the lawyer can absolutely tell the child, like, kiddo, I know you want to go home, or I know you want XYZ, but it's not safe and it's not going to happen. So let's have an alternative position. That happens all the time. And that is just good lawyering. So I don't want anybody to leave this seminar thinking that the best interest of children is not front and center. This law puts that assessment exactly front and center. Yes.
This is
with me, which I can definitely do.
no, this is a good question. I think a lot of them, there's two more that haven't been asked or touched on yet. One is, can a youth fire their lawyer?
Can a youth fire their lawyer?
Yes, that is the question.
A foster child would have to get court approval for that. I mean, just by the fact that they're not 18 and the guardianship of them lies elsewhere. But I can say in certain circumstances, I can see that happening similarly, well, identically to how a parent's lawyer could advocate for a change in lawyer. So if a child were to ask a lawyer, this isn't a fit for me, I want to fire you, the lawyer would be obligated to present that to the court, and then that would be a court decision.
And then the last one that hasn't been addressed in any of these answers or the PowerPoint is, will you offer another webinar to update everyone after the law has gone into effect?
Well, we would love to, and it would either be me or Brittany, and that is a great way to end because any future webinars or series or education that we do, the easiest and best way to find out about them, as you already know, is by subscribing to our website, genjustice.org. And occasionally we are going to have webinars that are not sent out to bulk emails, but we will send them to an internal email address of people who have asked for information. So again, if you haven't subscribed, please do. If you have questions or follow up on this, again, hello@genjustice.org. Part of Gen Justice is a children's law clinic, and part of that clinic are educational series like this on the legal rights of children and other varying topics. And so I hope you like this format because it's a great way, A, in COVID, but B, just to take a quick lunch hour and get a little information out there. And if you have ideas for webinars or things that you're confused about, we would love to learn them. But please know that one of the things we will be doing this year is offering more courses and education and PowerPoints like this on different laws and different issues. So my quick answer without having prepared that is that we could absolutely do something like that after the court rules are cemented. Any other last questions before we sign off, Brittany?
Let me just scroll through quickly one last time to see. I think we touched on most of these.
Well, I'll just say thank you. Are we good?
There's a couple more, but I don't think it's ones we have answers to. It'll depend on the court rules and things. Okay, so
well, because we're heading into 12:15, and I really wanted to keep this short and a good 45-minute lunch hour. So for those of you that are working, you can go grab your sparkling water, which would be my beverage of choice, and take a quick break before you go back to the office or your children or whatever you're doing today. And I just want to say thank you again. Our turnout for this was phenomenal. And that is amazing to see that all of you want to help support these kids in foster care. Lastly, I'm going to do a plug again, genjustice.org. If you missed anything or have a question, please email hello@genjustice.org, and we will get it to the right person and make sure that you get an answer to your question. And thank you very much. We'd love to get your feedback on how you liked this format, and we'll keep you in the loop. Thank you.